And they are called, it is called wall observation. So dear friends, just keep in mind that cross-examination is very easy thing. You can put any question to the witness because in my 20 years experience as a judge, I have found that the prosecutor sometimes play a trick. They put leading question to the witness. And when other side says, oh sir, this is leading question, he says, oh okay, I'm sorry sir, but purpose is over. So it is called trick of examination engine. With these words, I am very much thankful to all the audience, all the speakers.
Now understand the rulings.
Yeah. And as far as this case is concerned, I would have acquitted the accused. Thank you very much.
Thank you.
All right, over to you. You can ask leading and non-leading questions, preferably questions. So anyone in the audience, and you've got someone with a microphone, put your hand up and fire away.
But now ma'am said that we started it.
Yes, you've got it.
Yeah.
So it's a very general question. We've seen a lot of times during the trial that a witness turns hostile. And it is the job, I mean, it can either lie on the prosecutor or the defense counsel to use the situation of a hostile witness in their favor. So like for example, if I'm a prosecutor and my witness has turned hostile, how do I establish in the court of law that whatever I was trying to prove to the court is true? Because the witness I was trying to propose to the court is nowhere in my favor. So what is that one advice you would give?
Is your question how do you determine whether your witnesses become hostile?
No, sorry, my witness is already hostile.
Well, if you're leading your witness in chief as the prosecutor and your witness becomes hostile, it gives you the ability to turn it around and become a cross-examiner. So you cross-examine your witness in relation to that they're no longer your witness, in effect. And in Australia at least, in criminal trials, all of the prosecution witnesses will have provided statements. So all the court, the parties have all got a copy of the statement of your prosecution witness, and if they don't give evidence in accordance with that, and you determine that they've become hostile, you then cross-examine them based on their prior inconsistent statement.
Should we follow a process first?
There is a process for anything.
We need leave of the court.
Thank you, sir.
Next question, one over here. Yes, one at the back. All right, it looks like we've got, here we are, and at the right.
Sir, like we all know that we need to do and cross-examination with questions. We all know to go on, but we don't know where to stop. Like sometimes it goes against us, like our case or whatever. So where to stop in cross-examination? Is there any like wall or something where we should stop or where we should control ourselves?
I think knowing when to stop in cross-examination is without doubt probably the hardest or one of the hardest things to come and learn. It's learned through experience and experience only. It's learned through intuition. It's learned from appreciating and understanding your case theory so well that you know that you have got everything you can from that witness that you need to help your case theory. So my answer is ultimately there's no rule. It's all about experience and having that knowledge as to when to stop.
Just to add to that, I always try and have in the back of my head what my submission is going to be about that witness. So if I've gotten to a point of cross-examination where I can make that submission at the end of the case, that's usually when I try and stop.
Can I give you an example in this way? I did a case a long time ago, 10 years ago, maybe 15 years ago, where I had absolutely lost the case as a result of the evidence given by my witness. So in cross-examination, the cross-examiner had done a good job, asked a question, my witness answered that question, and I lost. But then he did something else. won the case. What did he do? He asked the same question again, and the witness gave a different answer. And then the cross-examiner got really concerned. So what did he do? He asked the question a third time. And the judge in the judgment ultimately said, I didn't understand what this witness's evidence was on this particular issue. But had they stopped after the first question, I had lost the case. It's a matter of experience, ultimately.
Thank you. And one thing I would like to add, there is no rule where to stop or where you can stop yourself. Just read the face of the judge. If you tired, stop there. Thank you, sir.
Any other questions? You've got a terrific opportunity here with the final panel. So, yes, lady at the back.
Good afternoon, hello sir. Really nice presentation. I would like to ask if you can give any advice or something that you notice, a trick that tells you that there is no need to cross-examine this question, that it's fine if you skip cross-examining a witness.
Knowing whether or not to cross-examine a witness, again, depends entirely on and working out whether that witness has done you and your case theory any harm. It is when we go to a trial, before that trial, we would have prepared material for cross-examination of all the witnesses. That's not the hard thing. The hard thing is knowing whether to stand up or not. And again, that is a determination of whether that witness has caused you to be concerned that your case theory is under jeopardy by what that witness has said in chief. If they have, you're required to stand up and try to address it. If they haven't, then why would you cross-examine them? The biggest danger in cross-examination is the witness says something which was unpredicted, which is what Professor Younger was talking about, which has come out of left field, which you didn't expect or predict, and it ruins your case theory.
And I just want to add to that point, remember the psychology of the courtroom. If the witness box is itching to tell her story, examine that witness, she is bursting to tell it. She wants to tell everybody what happened. And one of the commandments was to ask only leading questions, non-leading questions, which put that case to the witness, and it's yes or no, I don't know. That's what you want. If you open the door with why, and Mark took a great risk by asking what did you do, that's opening the door for a witness to run through it and tell that story. So in your mind, you must be thinking all the time, has that witness hurt my case? Do I need to cross-examine? And bear in mind, they want to tell their story. Any other questions? I think there was one. Yeah.
I'm just going to say something that's probably more embarrassing for me than anything else, but when I first came to the bar, I did my first trial within 3 weeks of coming to the bar, and it was in our lowest jurisdiction, and I had a self-represented against me, so I never knew what the self-represented was going to say. And it's a jurisdiction where it's not done by affidavit, so it's all giving of evidence and cross-examination. And I had convinced myself that the applicant, it was the defendant in that case, was lying. So he's in the witness box. I knew he was lying, and I just didn't have enough evidence to get it out of him. So, I broke one of those commandments, which is always know the answer to the question. But it actually worked out in my favour, very, very, very fluke. It was fortunate for me that it worked in my favour. And he had sent a text message to my client, and I said to him, "Did you send that text message?" He said, "Yes." I said, "And that text message said this?" "Yes." "Now that's not true, is it?" He said, "No." "Sorry?" And it was all about owing some money. He said, "No, it's not true." I said, "So you do owe the money?" "Yes." "And so you've come and you've lied." And I pushed it, I kept going, "And you've lied today. You've come here, and what you're saying now, you've lied." And I'm just sitting there going, "No, you're not done." And he's like, "Yes." And I sat there and I looked at the magistrate and I didn't know what to do. I know, and this is the point of sitting down, because I've just won my case. I've convinced him to say he's lied, which, as Mark explained early on, and Peter explained, sorry, those things don't happen. And I didn't know what to do, and so I looked and said, Your Honour, I call for production of his bank statements. Because I wanted to make sure where the money went. And she looked at me and she went, Are you sure? Do you think you need them? I was like, no further questions. And it was really embarrassing for me, but it's that learning when to stop. And it was actually the magistrate in that case that sort of said to me, okay, you can sit down now. So,
Any other questions? Comment from the front, Mr. Hayes would like the microphone.
I thought that we might bring, you're all young practitioners, and when you get to the bar, like Tennille was, she was a young practitioner at the bar during her first case, you can't overlook human nature being what it is. You, as young practitioners, want to make your point with your client. When your client is in court with you, you are always going to be thinking, now, what does he think of my performance? What should I be doing? And in civil cases, this is the hardest thing to do with, as Marcus said, when you know, as a lawyer, you know that there is nothing more that you can get from the witness by cross-examining the witness. But what you're thinking is, well, if I don't ask any questions, what's my client going to be saying? He's going to say, what am I paying this person for? They're not asking questions. And that's the hardest thing that you have to overcome. You'll find it very difficult to overcome. Not only young practitioners, but much more experienced practitioners are constantly playing to their client. And you tend to then overlook the issues, or the issues get clouded because you're giving way to that existential pressure from your client. So that's just human nature what it is. And no amount of flamboyant performances like Mr. Younger will be able to get you over that, because you'll always feel that pressure. Be aware of it.
So in cases which are in camera cases or in trial, or cases which are of very heinous nature, or where the victim has suffered a lot of trauma, it becomes very difficult for the examination in chief, because either the witness is so traumatized that he or she is not able to speak anything, and I mean, it is the main role of the examination in chief to get out all the important facts. But in such a delicate situation, where you have to maintain the dignity of the court as well as make sure that all the answers are before the court, what is that one piece of advice you would give all of us, that how do we handle such delicate situations?
I'd like to make a comment, because it's a very important point. What you've seen today is entry level. No disrespect to the counsel or witnesses, it's entry level. When you get to the, let's say, 5-star level, you're dealing with vulnerable witnesses, particularly child witnesses in sex assault cases. Terribly, terribly difficult. And when I opened it, I said that cross-examination is a privilege and not a right. It's something that counsel need to take very seriously. You've got a person who may be young and vulnerable. They may speak another language, and I've had this experience where the translator, who was the same ethnicity as the witness, obviously spoke a common language, was literally coaching the witness during my cross-examination. And I only knew that because my instructing solicitor happened to speak that language fluently and knew that what was being translated in and out of the witness was a complete concoction by comparison to what my questions were. Now, I would not have known that. Now, that's one case we're talking level 5, in cross-examination where things just get out of control because you're not really attuned to what's going on. But when you're dealing with that proposition, and I said, you will accuse people of unspeakable things, in criminal cases in particular. Miss Crown has to put her case to a witness who may have done unspeakable things to a child, for example. How do you put that to them firmly, fairly and respectfully? How do you lead that child witness and try and elicit a story from her about what occurred, sometimes years before, and she is as fragile as you can imagine. How do you do that? Now, rules of court and process have changed to allow for statements to be taken out of court, for the witness to keep her evidence away from the courtroom, remote and so on. So a number of techniques have been brought into play. Your question is a good one, beyond, I think, the level of what we can demonstrate today. But I'll give you one word to sum it up. Respect. You're part of a process, you have a privilege, and you need to treat that witness and the process with the greatest respect. Is that the answer? All right, I think that might be a strong note to finish on. I think thank you to the witnesses to the extent they discharged their duty. And you'll be pleased to know that the South Australian Police have launched an investigation into him. Firstly, there's relationship with the accused.
I'm not the accused, I'm a witness.
Well, you're the witness, even worse. and his general incompetence and ineptitude. So Harry is soon to be removed as a police officer. Special thanks to Mark and his bravery or courage in asking